All names, places, and institutions are aliases used to protect privacy. Procedures and timelines reflect real-world law and court practice for immersion. The air in Atlas Hall tastes like furniture polish and fear. Court reporter Weaver's fingers hover above the steno keys as Judge Keystone lifts a single sheet of paper from the defendant's file. The same file she read before lunch when she announced a tentative sentence of 18 months for defendant Rook, a first-time felon convicted of aggravated assault with a deadly weapon. Now 4 hours later she reads one line aloud. Prior case dismissed in Granite County, 2016, identical circumstances. No prosecution due to complaining witness leaving jurisdiction. Silence spreads through the gallery like spilled ink. Defense attorney North stands frozen at the podium, his hands locked on the oak rail, because the plea agreement his client signed this morning was built on a single premise that has just collapsed. Rook was a clean defendant with no criminal history whatsoever. Prosecutor Slate shifts in her chair, her expression unreadable, because she knows what North does not yet understand. This hearing is about to become a procedural minefield where every word spoken will be preserved on the record for review by an appellate court and the state bar. Before the chaos, subscribe and drop a comment on how far judges can go when new information surfaces at sentencing. You might be surprised how thin the line is between discretion and reversible error. 3 months earlier, Rook walked into North's office on a rainy Monday in Riverbend, carrying a charging document that accused him of striking another man in the face with a tire iron outside a roadside tavern called the Gravel Lot. Witnesses said the victim, a local contractor named Marlowe, had shouted at Rook about an unpaid debt. Rook claimed self-defense when Marlowe reached for something in his truck bed. Prosecutor Slate's initial offer was harsh. Plead guilty to aggravated assault, accept 36 months in county lockup, or go to trial on charges that could carry 8 years if a jury believed Marlowe's version. North spent 2 weeks reviewing police reports, interviewing witnesses who saw the confrontation but could not agree on who moved first, and studying Rook's background, a construction laborer in his early 30s. No arrests, no convictions, clean employment history, community ties. Slate eventually softened her stance after a pre-trial motion hearing, where Judge Keystone suggested both sides recalibrate expectations given the shaky witness testimony and the lack of surveillance footage. The plea deal that emerged promised a cap of 18 months in exchange for Rook's guilty plea to a reduced charge, with Slate acknowledging on the record that Rook's lack of prior criminal history was a significant mitigating factor, justifying leniency. North had handled dozens of plea negotiations in his 7 years as a defense attorney in Granite County and neighboring jurisdictions, but this case felt particularly straightforward. Rook was cooperative, articulate, and genuinely remorseful about the confrontation. He had been working steadily for the same construction company for 9 years, living in a modest rental house on the outskirts of Riverbend, and had never been arrested or charged with a crime in his adult life. North conducted his standard background check through the state criminal database, which returned no results. He asked Rook directly, multiple times, whether there was any history of police contact, arrests, or charges anywhere in the state or beyond. Rook answered no every time. North believed him. The plea agreement was drafted, signed, and filed with the court 3 weeks before the scheduled sentencing hearing. Both sides expected a routine proceeding, victim impact statement, defense mitigation presentation, judicial acceptance of the agreed sentence, and dismissal. North even told Rook's sister, who planned to attend the hearing, that her brother would likely be reporting to county lockup that same afternoon to begin serving his time with credit for the 2 weeks he had already spent in custody immediately after his arrest. The sentencing hearing this afternoon began as a routine proceeding. At 2 o'clock, Clerk Bellamy called the case. State versus Rook, case number 47-CR-892, sentencing on guilty plea. North and Slate rose, announced their appearances, and the courtroom, sparsely populated with a few curious spectators and Rook's sister in the back row, settled into the familiar rhythm of a negotiated disposition. Slate offered a 3-minute recitation of the facts underlying the offense, emphasizing the injury Marlowe sustained, a fractured orbital bone requiring surgical repair, and the danger posed by using a metal tool as a weapon. She read from a victim impact letter Marlowe had submitted, describing months of medical treatment, ongoing vision problems in his left eye, and the financial strain of missing work during recovery. North responded with a 12-minute mitigation argument, presenting letters from Rook's employer, his pastor, and a neighbor attesting to his character, his remorse, and his willingness to pay restitution. He hammered the absence of any prior convictions as proof that this incident was an aberration, not a pattern. Judge Keystone listened, asked Rook if he understood the consequences of his plea, and then announced a tentative sentence of 18 months as agreed, subject to final calculation of custody credits and a probation report review after the lunch recess. The courtroom emptied. North told Rook the worst was over. When Judge Keystone returned at 3:40, she carried a supplemental memorandum from the probation department that had been filed electronically during the break. The memo flagged a case discovered through a cross-jurisdictional database query, an assault charge filed against Rook in Granite County 9 years ago involving nearly identical facts, a confrontation outside a bar, an allegation that Rook struck another man with a blunt object, and charges that were dismissed when the complaining witness relocated out of state before trial. The probation officer's note was clinical. Defendant may have omitted prior contact with law enforcement. Impact on sentencing, weight of no criminal history unclear. Recommend court inquiry. Keystone studied the memo, then opened Rook's plea file and cross-referenced the probation interview form, where Rook had answered no to the question, "Have you ever been arrested or charged with a crime other than this case?" That answer, given under oath during the plea colloquy, suddenly cast the entire plea negotiation in a different light. Keystone called the case back into session and read the single line aloud, watching North's face drain of color as the implications registered. If Rook had lied about his history, the plea deal's factual foundation, his status as a first-time offender, was compromised, and the court's discretion to impose a sentence beyond the agreement was now in play. North stepped to the podium and asked for a sidebar. Judge Keystone denied the request, insisting that any discussion of this issue must be on the record to preserve transparency and prevent later claims of ex parte communication. She told North he had 5 minutes to confer with his client at the defense table, then returned to the bench to wait. Rook leaned close to North, whispering urgently, and North's expression shifted from confusion to alarm. When Keystone resumed, North rose and addressed the court with careful words. "Your Honor, my client informs me that he was arrested in Granite County in 2016, but he believed the question referred only to convictions, not dismissed charges. He did not intentionally mislead the court." Keystone's tone was flat. "Counselor, the plea form asks about arrests and charges. The probation interview asked the same. Your client answered no to both. That is a material misrepresentation under oath, and it affects the sentencing calculus because the plea agreement relied on the representation that he had no prior violent incidents." Slate rose. "The state moves to withdraw from the plea agreement, Your Honor. The defendant's misrepresentation undermines the basis for our negotiated cap." North's response was immediate. The state cannot unilaterally withdraw after the court has accepted the plea. The remedy, if any, is for the court to consider this information as an aggravating factor, not to void the agreement post-acceptance. The legal battle lines were drawn. Judge Keystone paused, then explained the law aloud for the record. Under the sentencing statutes governing Riverbend's jurisdiction, a judge retained discretion to consider aggravating factors, including prior arrests and uncharged conduct, if those facts were proven by reliable evidence and disclosed to the defendant before sentencing. The dismissed Granite County case was documented in official court records. Rook had been given notice of the probation memo, and the court had an independent duty to ensure the accuracy of the factual basis for any sentence it imposed. Keystone continued. The plea agreement caps the sentence at 18 months based on the state's acceptance of mitigating circumstances, specifically the defendant's clean record. That record is not clean. The court is not bound by the agreement if the factual predicate was false. However, because this issue arose late, I will give both parties an opportunity to present argument on whether the prior arrest constitutes an aggravating factor sufficient to justify exceeding the cap. The gallery murmured. Deputy Holloway stepped forward to quiet the room. North asked for a continuance to prepare a response. Keystone denied it. This is a sentencing hearing, Counselor, not a trial. You have the facts. You can argue them now or waive argument. North chose to argue. He began by challenging the reliability of the probation memo, pointing out that dismissed charges are not convictions and should not carry the same weight in sentencing. He cited the principle that a defendant is presumed innocent of any conduct not proven beyond a reasonable doubt, and argued that using a 9-year-old dismissed case to enhance punishment violated due process and double jeopardy protections. North's voice grew more forceful as he pressed the fairness issue. Your Honor, my client had no reason to believe a case that was dismissed without prosecution would be held against him. The state never moved forward on those charges. No jury heard the evidence. No judge made findings. Using that case now, at this late stage, after the plea has been accepted, is fundamentally unfair and contrary to the principles that govern plea bargaining. If the state had wanted to investigate my client's background more thoroughly, they had months to do so. They cannot now claim surprise and seek to undo an agreement that both parties entered in good faith. Slate countered with case law establishing that judges may consider prior arrests as evidence of a defendant's character and likelihood of recidivism, especially when the arrest involved conduct similar to the offense of conviction. She argued that Rook's failure to disclose the prior case suggested consciousness of guilt and an intent to manipulate the plea process. Slate's voice was calm but firm. Your Honor, the defendant had a duty to be truthful in his dealings with the court and with the probation department. He signed a form under penalty of perjury, stating that he had never been arrested or charged with a crime. That was a lie. Whether he understood the question or not is irrelevant. He could have asked for clarification, he could have consulted with counsel, he could have disclosed the arrest out of an abundance of caution. He chose not to. The state entered this plea agreement based on the defendant's representations. Those representations were false. The court should not reward that dishonesty by adhering to a cap that was obtained through misrepresentation. But the exchange escalated. North accused Slate of bad faith gamesmanship by waiting until after the plea was entered to raise the issue, and Slate accused North of willful blindness for failing to investigate his client's background before negotiating the deal. Judge Keystone raised her hand. Enough. I have heard sufficient argument. I will rule. Keystone's ruling was surgical and devastating. She found that the prior arrest, though not a conviction, was admissible as evidence of a pattern of violent behavior involving the use of objects as weapons. She found that Rook's failure to disclose the arrest constituted a material misrepresentation that undermined the factual basis for the plea agreement's sentencing cap. She found that the aggravating factors, prior similar conduct, dishonesty under oath, and the severity of the victim's injury, outweighed the mitigating factors North had presented. Then she announced the new sentence. The court imposes 36 months in county lockup, with credit for time served. The defendant is remanded immediately. Rook's face went pale. His sister gasped in the gallery. North stood frozen, his mind racing through the appellate issues he would need to preserve. He asked the court to state its findings more specifically for the record, and Keystone complied, reciting the aggravating factors one by one and explaining how each justified the doubling of the sentence from the agreed 18 months to the full 36. Then she nodded to Deputy Holloway, who approached the defense table with handcuffs. But North was not finished. He rose again and made a motion for the court to reconsider or, in the alternative, to stay the sentence pending appeal. He argued that the court's reliance on a dismissed charge violated his client's due process rights because the state had never proven the underlying conduct in Granite County beyond a reasonable doubt, and that the court's decision to exceed the plea cap after accepting the plea amounted to a bait-and-switch that punished Rook for exercising his right to plead guilty. North's voice carried an edge of desperation. "Your Honor, if you allow this sentence to stand, you are sending a message that defendants cannot trust plea agreements. My client negotiated in good faith. He relied on the state's representation that 18 months was the appropriate sentence. He gave up his right to trial based on that representation. To now double his sentence based on a case that was dismissed 9 years ago, a case that the state in Granite County declined to prosecute, is not justice. It is punishment for an offense that was never proven." Keystone denied the motion to reconsider, but granted a brief stay, 72 hours, to allow North to file an emergency appeal with the state appellate court. Rook was released on his original bond, and the hearing adjourned. As the courtroom cleared, North gathered his files and saw Slate lingering near the prosecution table. She approached him and said quietly, "I didn't know about the Granite County case until this morning. Probation flagged it. I had no choice but to disclose it." North believed her, but the damage was done. He left the courthouse with Rook and his sister, promising to file the appeal immediately and to fight for a reversal. Rook said little during the drive back to his house, staring out the window at the rain-soaked streets of Riverbend. His sister asked North what the chances were on appeal. North answered honestly, "Better than most. The procedure here was rushed. The judge didn't give us time to investigate or challenge the probation memo. That's a due process problem. But appeals take time, and there are no guarantees." Within 48 hours, North filed a petition for emergency relief with the State Court of Appeals, arguing that Judge Keystone's sentence violated principles of fairness, proportionality, and double jeopardy. The petition focused on 3 points. First, that the use of a dismissed charge as an aggravating factor effectively punished Rook for conduct for which he was never convicted. Second, that the timing of the disclosure, after the plea was accepted but before final sentencing, created an appearance of unfairness that undermined confidence in the plea process. And third, that doubling the sentence based on a single line in a file, without affording Rook a full evidentiary hearing to challenge the accuracy of the probation memo, violated due process. The appellate court assigned the case to a 3-judge panel and scheduled oral argument within 2 weeks, an unusually fast track that signaled the court's concern about the procedural irregularity. The state filed a response brief defending Judge Keystone's discretion to consider all relevant information at sentencing, including prior arrests and dismissed charges. The brief argued that Rook's misrepresentation on the plea form was independently sufficient to justify exceeding the cap, because a defendant who lies under oath forfeits the benefit of his bargain. The brief also pointed out that Keystone had given North an opportunity to argue against the enhancement in real time, satisfying procedural fairness requirements. But the state's brief conceded one point: The probation memo had been filed only hours before the final sentencing, leaving North minimal time to investigate the Granite County case or present rebuttal evidence. That concession became the fulcrum of the appeal. At oral argument, the appellate panel pressed both sides on the fairness of the process. One judge asked the state's attorney if the defendant had known the Granite County case would be used against him. Could he have demanded an evidentiary hearing to contest the facts of that case? The state's attorney answered yes, but acknowledged that no such hearing had been requested or held. Another judge asked North, "Did your client affirmatively lie, or did he misunderstand the question?" North admitted he could not be certain, but argued that any ambiguity should be resolved in favor of the defendant, especially when the consequence was a doubled sentence. The third judge asked the hardest question of all. If we reverse the sentence, what happens to the plea agreement? Does the state get to withdraw? Does the defendant get to withdraw? Or does the case revert to the trial court for resentencing? Neither side had a clean answer, because the law governing post-plea sentencing challenges was murky and fact-specific. The oral argument lasted nearly an hour, far longer than the typical 15-minute session for most criminal appeals. The panel's questions were pointed and skeptical toward both sides. When the state's attorney argued that Rook had waived his right to challenge the probation memo by failing to request a continuance, one judge shot back, "The trial judge denied the continuance request. How can you say the defendant waived something he was not allowed to do?" When North argued that the dismissed Granite County case should be categorically inadmissible, another judge countered, "But your client admitted the arrest happened. He just claimed he misunderstood the question. If he admits the facts, why do we need a hearing?" North struggled to articulate a response that balanced his client's admission with the broader procedural concern that rushed sentencing hearings based on late disclosed information created systemic risks for all defendants, not just Rook. 3 weeks later, the appellate court issued a split decision that reversed Judge Keystone's sentence but left the plea intact. The majority opinion held that while a trial court has broad discretion to consider aggravating factors at sentencing, that discretion is constrained by procedural fairness when the factors are contested or disclosed late in the process. The opinion noted that Rook had not been given a meaningful opportunity to challenge the accuracy or relevance of the Granite County case because the probation memo was filed the same day as the final sentencing hearing, and because Judge Keystone had denied North's request for a continuance to investigate. The majority concluded that the sentence violated due process, not because dismissed charges are categorically inadmissible, but because the procedure used to consider them was inadequate. The court remanded the case to Judge Keystone with instructions to hold an evidentiary hearing on the Granite County arrest, allow both sides to present witnesses and documents, and then resentence Rook based on findings supported by the record. The dissenting judge argued that Keystone had acted within her discretion and that any procedural defect was harmless because Rook had admitted the arrest existed, making an evidentiary hearing pointless. The reversal sent shockwaves through Riverbend's legal community. Prosecutors worried that the decision would encourage defendants to withhold information during plea negotiations, knowing that late disclosed aggravating factors might be excluded on appeal. Defense attorneys welcomed the decision as a check on judicial overreach and a reminder that sentencing discretion is not limitless. Judge Keystone, reading the opinion in her chambers, felt the sting of appellate rebuke and questioned whether she had moved too quickly in her eagerness to correct what she saw as a dishonest plea. She convened a meeting with Clerk Bellamy and court reporter Weaver to review her protocols for handling late-filed probation memos, determined to avoid a repeat scenario. Keystone drafted a new standing order requiring all probation reports to be filed at least 7 days before sentencing, with automatic continuances granted if new information surfaced within that window. She circulated the order to the attorneys who practiced regularly in her courtroom and most welcomed the clarity it provided. The remand hearing took place 6 weeks later, this time with both sides prepared. North subpoenaed records from Granite County and presented testimony from the former prosecutor in that case, who explained that the charges were dismissed not because Rook was innocent, but because the complaining witness had moved out of state and refused to return for trial, a pragmatic decision, not an exoneration. The former prosecutor, a veteran attorney now in private practice named Brennan, testified that the case had been strong on the merits, with multiple witnesses and physical evidence, but that pursuing a trial without the victim's cooperation was not feasible. North cross-examined Brennan, pressing him to admit that the decision to dismiss meant the state had never proven Rook's guilt. Brennan conceded the point but added, "The law presumes innocence, but that doesn't mean innocence was proven. It means we couldn't prove guilt. There's a difference." Slate presented testimony from Marlowe, the victim in the current case, who described the severity of his injury and the lasting impact on his ability to work. Marlowe, a soft-spoken man in his mid-40s, testified that he still experienced double vision in certain lighting conditions and that his medical bills had exceeded $30,000, most of which remained unpaid. North objected that Marlowe's testimony was irrelevant to the narrow issue of the Granite County case, but Keystone overruled him, stating that victim impact was always relevant to sentencing. Rook himself took the stand and testified that he had not disclosed the Granite County arrest because he believed dismissed charges did not count as a criminal record and because he was ashamed of the incident. On cross-examination, Slate asked Rook if he had consulted with North before answering the probation questionnaire. Rook said he had not, that he filled it out alone at home and returned it by mail. North objected that the question was outside the scope, but Keystone overruled him, noting that Rook's credibility was directly at issue. After hearing all the evidence, Judge Keystone issued detailed findings. She found that the Granite County arrest did involve conduct similar to the current offense, and that the dismissal was due to witness unavailability rather than lack of probable cause. She found that Rook's failure to disclose the arrest was negligent, but not intentionally deceitful, because he had genuinely misunderstood the scope of the question. She found that the aggravating factors, the prior incident and the severity of Marlowe's injury, were substantial, but that the mitigating factors, Rook's employment history, his remorse, and his willingness to pay restitution, also carried significant weight. Balancing all the factors, she imposed a sentence of 24 months, midway between the original 18-month cap and the 36 months she had ordered at the first hearing. Rook accepted the sentence. Slate did not appeal. North filed a notice preserving his client's appellate rights, but did not pursue further review. The case left scars that extended beyond the parties. Judge Keystone began requiring probation memos to be filed at least 1 week before sentencing, and she instituted a practice of disclosing any new information to counsel in writing, with a clear opportunity to request a continuance or an evidentiary hearing. Prosecutor Slate revised her office's plea negotiation checklist to include database queries for dismissed charges and out-of-jurisdiction arrests, before finalizing any agreement that relied on a defendant's clean record. Defense attorney North started advising clients to disclose every arrest, charge, or police contact, no matter how old or seemingly irrelevant, and to consult with him before completing any probation questionnaire. The local bar association held a continuing education seminar on sentencing procedure, and Judge Keystone was invited to speak about the lessons learned from the Rook case. She accepted, framing the experience as a reminder that the power to sentence carries a duty to ensure fairness at every stage, even when a defendant's dishonesty tempts a court to act swiftly. Rook served his 24 months, was released on probation, and returned to work in construction, his record now bearing a conviction that would follow him for life. Marlowe's medical bills were paid through a restitution order, though the physical scars from the assault remained. North kept the appellate opinion in a folder on his desk, a reminder that the line between discretion and error is drawn not by intention, but by process, and that a single line in a file can double a sentence only if the procedure used to weigh that line can withstand scrutiny by judges who were not in the room when the decision was made. Years later, a law student researching sentencing procedure came across the published appellate opinion in the Rook case and contacted North for an interview. The student asked whether North believed his client had lied or simply misunderstood. North paused before answering, "I don't know, and in some ways it doesn't matter. The system is supposed to resolve that kind of ambiguity through a fair process, not through a rushed hearing where one side gets blindsided by new information." What happened in that courtroom wasn't about finding the truth. It was about power. Who has it, who wields it, and what happens when someone tries to wield it without following the rules. The student asked whether North had stayed in touch with Rook. North said he had not, that most clients moved on after their cases ended, and that he respected their desire to leave the past behind. Late at night, when Atlas Hall is dark and silent, the empty courtroom holds no answers, only the faint smell of furniture polish and the knowledge that justice, when rushed, can feel like fear. Judge Keystone sometimes walks through the building after hours, checking the posted dockets for the next day's hearings, and when she passes the courtroom where the Rook case unfolded, she remembers the look on North's face when she read that single line aloud, the shock, the betrayal, the desperate scramble to protect a client who had either lied or simply failed to understand what the system demanded of him. She wonders whether she made the right call, whether the appellate court was right to reverse her, whether the final sentence of 24 months was more just than the 18 months she had initially promised or the 36 months she had tried to impose. There are no clear answers, only the record, thousands of words transcribed by Weaver, preserved in digital files and paper volumes, waiting for the next lawyer or judge or scholar to review and interpret and argue over. That record is all that remains, a monument to the idea that fairness depends not on what a judge intends, but on what a judge does, and whether the process used to reach a decision can be defended when someone who was not in the room asks why. If you've ever wondered how a single piece of information can reshape a life, how the rules that govern courtrooms are supposed to protect everyone, even defendants who make mistakes, then share your thoughts in the comments and subscribe to explore more stories where the law's promise of fairness collides with the reality of human imperfection.